and fingerprint expert and forensic question document expert. Shri Mishra has appeared as an expert witness in international courts, including the Singapore International Commercial Courts, especially known for its arbitration matters, and the Supreme Court of Mauritius. Shri Mishra holds MSc, LLB, and PG CFSC First Division in Delhi University, and also has been received field training at the Center Forensic Science Laboratory with Central Bureau of Investigation, New Delhi. Shri Mishra has also completed 2 years of apprenticeship under Shri V.N. Sehgal, former director of CFSL, CBI, New Delhi, and is a registered advocate with the Bar Council of Delhi. Today, we are truly privileged to have such an experienced expert with us today. I now invite Shri Manas Mishra to begin the session and share his valuable insights. Thank you for joining, everyone. Thank you so much, sir. Over to you now.
Thank you, Soumya, and thank you the entire team of Law Codified for having me here. And it's a pleasure, first of all, to always address so many young budding lawyers, upcoming lawyers, and people who are practicing law. So it's always an honor. And today's session, since I was told that we are going to talk about forensic document examination and its importance in the legal system. Now, somebody asked me whether can you suggest any other title to this webinar? So I was of the view that this is more suitable because when I am addressing a lot of people in the past, also I've addressed. I make sure that if I have to cover so many topics, since it's a very vast field, forensic science is a vast field, and there are so many different branches, and I'm just handling a very small branch, which is question documents, which deals with the disputed documents, where we come across terms like forgery, we come across terms like disguise, we come across terms like whether the document is genuine or not. We need to do an inspection of the document, and an expert needs to provide a fingerprint report or thumb impression analysis has to be done. So that's why I kept the title as its importance in the legal system, because there are various aspects I would like to touch upon during this webinar. So it is very difficult for somebody like me to actually pinpoint and to provide a presentation kind of a thing, because I am mostly speaking impromptu in all my webinars, seminars, whatever it is. So it always helps, and moreover, I don't want to keep it as a one-sided traffic. This entire webinar would be, I would want to be it to be an interactive one. So I would request everyone that in case if you have any question, or if you want me to explain something in a much different manner, in a much easier manner, or maybe I'm also going to touch upon certain cases whereby I have submitted opinion and what were my experiences, both national, international. So having said that, now coming back again to forensic science. So handwriting expert, now this is a vague term in terms of explanation, and in the past I have had so many encounters whereby somebody used to ask, like, what do you do? So once I tell them that we are handwriting expert, or I'm a handwriting expert, so their first reaction is, okay sir, please see my handwriting and tell something about my personality, or something about my future, or something about myself. So that is graphology, and that is not a pure science, that is a pseudoscience. I don't, I'm not a graphologist. I don't look at the handwritings, and I don't tell personality traits. So that is the first thing. Second is, when people hear about handwriting expert, they feel that people, they come up to me and they say, sir, my son's handwriting is very poor. I want you to kindly tutor him, or kindly help him in improving his handwriting. Well, that is also something that we don't do. I don't change people's handwriting. I don't train them to work on their handwriting. That is something else that we don't do. So we are strictly forensic handwriting experts. Now, when I introduce this term forensic, it is pertaining to the Honorable Court. So the branch of forensic science where application of documents is taken care of. We talk about the different kinds of documents, and the presentation of the documents is made before the honorable court. So whenever there is any case, whenever there is any dispute in the honorable court regarding or pertaining to documents, that is handwriting, signatures, thumb impressions, body writing. So we provide expert opinions under Section 39 of Bharatiya Saksh Adhiniyam, which was previously Section 45 of Indian Evidence Act. So this is what is basically what we do, me and Dr. Mishra, both of us, and this is what is required of a forensic handwriting or a forensic document expert. So this is the entire 2 hours webinar is going to cover aspects pertaining to document analysis only. Now, when we talk about documents, uh, when we are born, right from the time when we come into this world and right till the time we stay here in this world, we are surrounded by different kinds of documents. When we are born, there is a birth certificate. When we die, there is a death certificate. So these two important documents validate our existence in this world. And during this period, we as a student also, as a professional also, we come across so many different kinds of documents. So having said that the documents are there, we are surrounded by documents, then what really allows, or what really requires an expert, or when is an expert basically required in the honorable court? So our application comes into the picture, we come into the picture whenever there is a dispute, जब भी कोई विवाद होता है. So whenever there is a uh, disputed document. Now, when does a document is said to be disputed? So when you must be knowing that whenever there is a transaction, whenever there is an agreement made between two individuals, uh, both the parties, they sign different kinds of documents. So what all documents are there? Agreement is there. There is a will. There are checks. There are settlements, settlement deeds. There are different kinds of other deeds. There are letters. There are guarantee letters. There are pro notes. Right. So these are some of the important documents that we come across on a daily basis. So whenever there is a signature which one party or the other party is disputing, they are denying that I did not sign on this particular document, or these are not my signatures, or I don't remember when did I sign it, and I'm 100% sure I did not sign it. So whenever there is certain ambiguity about a particular signature, or it could be also the body writing. uh, in most of the documents, when the entire document is handwritten. So when I say handwritten, when I talk about holographic will, so in an holographic will, what happens is the entire will is written handwritten. So if the entire will is handwritten, so that body writing also becomes a point of contention, becomes a point of concern, becomes a point of dispute. That which particular person has written that will. So the writing also becomes a matter of contention, and we have to examine and compare the writing as well along with the signature. And when I talk about the writing part, it could be a Hindi writing, it could be an English writing, it could be a Gujarati writing, it could be some other script. Suppose if it's a Japanese script, so the entire thing could be in Japanese also. So irrespective of which script we are talking about, the entire document becomes disputed. So not only the alphabets, not only the words, not only the sentences, but also there are certain aspects, there are different aspects in a document pertaining to the dates. So if somebody has written a date, a particular date on a document, so that date also needs to be examined. If somebody has made any particular diacritic mark, or some sort of a cross, or an ambiguous mark, so that mark also becomes disputed, and that mark also becomes a point of concern. So the entire contents of a particular document at times is also a matter of dispute. So, for example, if there are two signatures and one signature is disputed, so our job is to identify and examine the signature which is disputed first of all, and there are certain parameters that have to be touched upon, uh, whether on what date the document is alleged to be signed, if whether or not we have good comparatives to compare the disputed signatures with the admitted signatures or the specimen signatures. Now, there is a huge difference between these two exemplars. I'll discuss about this a little while in my next slot. I'm going to talk about it. Also, what are the three different issues mostly for us? Because it appears to be a very difficult and very tricky science, but to make it more simply to simplify it little more and to make it more interesting, I would want to say that there are three major problems whenever an expert uh, looks disputed or examines a disputed document rather. So what are these three different kinds of problems? First and foremost is that I have written something. I have made an agreement. I have signed a check, whatever it is, and I just want to make sure that these are my signatures. I want to verify. The other party is saying that these are not your signatures, and they are claiming something else, or maybe the other party has signed a document, an agreement, and now they are denying it. They are denying it completely. They are saying I did not sign it. So the first problem is to prove a signature as genuine. When a genuine signature is to be proved as a genuine. For example, if somebody is saying that these are forged, so the first stage of examination is to remove the question of whether the signature is forged or not. So different tests have to be conducted, different comparisons have to be made. I'm not going to get into the scientific part of it because I don't think so. Most of you are budding lawyers, so I would want to stay at that level. So by thereby, it is difficult for you to understand. In case if you have any question, if you want me to go a little dive little deeper, let me know. I'll just make sure that if I could be in a position to explain it, because it's entirely a one-way traffic right now. I don't know the response. So let me know. So first and foremost is the genuine document, the genuine signature. So an examination has to be conducted whereby I have to opine, I have to find out whether a signature is genuine or not. So we have to consider so many different traits when we are comparing two signatures and both are genuine, both are done by one and the same person. So we have to test. First and foremost is the line quality, the line quality of any signature. Now, line quality is nothing but the quality of strokes that are written. Signature जो है उसमें tremors हैं कि नहीं, whether there are tremors, whether there are hesitations, whether there are concealed joinings, whether there are unnatural pen pauses, unnatural pen lifts, or whether there is pen jump. If the writing is very fluent, if there is rapidity of motion, if the speed is rapid, then there would be pen jumps. That means that the pen is moving so fast that it does not touch the surface of the paper directly, and we are left with a very thin stroke. So that's an indication that the signature appears to be genuine. Other than this, there are other traits as well, which are called as forgery traits. So we have to also make sure the anomalies, whether there any tremor, or is there any hesitation, or is there something very unnatural about the signature itself, and that too only after comparison with the actual signature. So we have to make sure that we have sufficient exemplars, sufficient comparative signatures with us. And a very important aspect, considering this particular problem, is the what is the exact number of signatures, the admitted signatures, because I might have a signature belonging to year 2017. Suppose there is a will, and the testator has signed, and the date of the will is 2017. Now we have to examine whether the signature and the testator who has made the will, he or she is no more. So now this becomes a point of question. Somebody disputes that will. Somebody says that, sir, this will appears to be forged, because our mother, our father, whomsoever is the testator, he or she hasn't made any such will, and there is another will which is with us, and things like that. So the most challenging part for any forensic handwriting expert at that particular moment is that what are the samples. So suppose if somebody died, somebody passed away in 2017, just right after making the will, 2 3 months later. So the problem is the problem is the lack of contemporaneous signatures. We have we have some admitted signatures of that person, but those are, from the year 2003, 2004, and I'm talking about the disputed will, which is 2017. So you can understand the gap. It's around 10 to 12 years gap, which is too much, because you must all of you must be knowing that, whenever we sign, and whenever, there's a long gap of time, our signatures tend to variate. They tend to vary a lot. Some people, they have this tendency of uh, fixed mannerism. They are natural. With the range of natural variations, it doesn't change much. While with some others, like including myself, if I sign in the morning and if I sign at the night, my signatures are drastically different. Now that is not because I am not that person who signed in the morning, but because I have a very very large range of natural variation. And also there are certain other factors which are responsible, which could be the external factors or internal factors. External factors such as, the surface on which I'm signing. So in the morning when I signed, I was sitting on a table and a chair. I signed it. My wrist was pretty much supported, and so the signatures were very fluent, and they look more like the way I sign. And by the night, I think I was maybe, standing somewhere, and somebody came and he just asked me casually to sign on some documents. I signed it, and I was busy. I was with some of my friends. I did not lay much emphasis on my signatures, to be very honest, at that time. So I just signed it in a very very, casual manner, very speedy. So the signatures, they appear slightly different, the morning signatures and the evening signatures. So now it becomes very challenging for any expert to identify the particular range of natural variation, because this is a big problem in this particular handwriting identification science. That and this is the major issue with this particular branch of forensic, because in most of the other forensic branches, including blood, DNA, thumb impressions, these are pure science, right? So if I have a thumb impression remains the same throughout my lifetime. It will not change, or I would say it will not variate. ऐसा नहीं है कि अभी I have a loop pattern on my thumb, and day after tomorrow I have an arch pattern, or day after tomorrow I have a whirl. It does not work like that, right? So whatever print I have today, it is going to remain the same. Yes, is there any question? Okay. uh, okay, good morning, sir. What are the preliminary examination techniques used for documents? Okay, this is Anu. So Anu, there are different. See, first of all, for an expert, it is the inspection that we make. So if a document is shown to me and they ask whether the signature is genuine, what basically I have to say about the signature. So my prima facie observation is, first of all, I examine the originals, whether the original is present with me or not, or whether I'm examining a photocopy. Now, since if it's an original, I would first of all make a microscopic examination. And if I don't have an access to microscope at that time, I would have a magnifying glass with me. I would have my a torchlight, and by simple transmitted light examination, I can find out whether the signature appears to be genuine or not. Now when I say transmitted light, now transmitted light means that if there is a signature, and suppose if this is the document and there is a signature on this document, so light is thrown underneath the document. So I have a torch light or a simple, low frequency light also. I can put it underneath a document, so the light passes through the signature. So when a light passes through the signature, I can examine the strokes in a much better way. I can find out if there is any anomaly, if there is any tremor, if there is any hesitation, or symptoms of forgery or not. So I'm convinced, if I, on first impression, if I found out there is no particular symptom of forgery, then it heavily implies that this signature appears to be genuine. Now again, I will not conclude there and then that it's genuine. I'll be conducting examination, comparative analysis. I'll be asking for admitted, just like I just mentioned, I will ask for the admitted samples of the individuals, and not only one or two samples, at least 5 to 10 is a good number. So if I have 5 to 10 comparative signatures, I have a good amount of data with me, provided that those are, I have almost 3 to 4 years gap between each and every signature. So it should that accounts for a good analysis, that accounts for a good examination. Why? Because I have touched upon the different ranges of natural variation throughout. Suppose if there's a period of 25 years, so I might be having 3 years or 4 years gaps. I have signatures provided to me belonging to 3 to 4 years of gaps, in gaps, so that I can find out, okay, between 2002 to 2006, these were his style of signature. But from 2007 to 2011, this particular style was adopted. The variation is slightly there, so I can see that the signatures are getting shorter and shorter, or the signatures are the alignment is going ascending or descending. So there are different aspects, so I can find out, okay, this appears to be a genuine signature. And the range of natural variations that I have seen over the period of 25 years or 10 years or 12 years, that same range of natural variation can be seen in the disputed signatures as well. So I'm convinced that the range is somewhere similar, and there is no line quality defect. Also, there is no symptom of any kind of a forgery. Then I would definitely conclude that the signatures are genuine. So preliminary examination basically, Anu, is for our eyes, because having seen so many documents over the last so many years, now it doesn't take much time for us to identify if there is any defect, or any particular symptom of forgery in any signature. So we right away find out. It's just, but it does not end there. uh, I might say that it's a forgery. I might say it's a genuine signature. At the end of the day, I have to convince the honorable court. And what really matters is how detailed an opinion is formed, how well I have demonstrated. See, it's a demonstrated science. It's a demonstrative science. Uh, an expert could be a highly qualified person. He must be having n number of degrees, and uh, he must be having a training material from various people. Doesn't matter, but at the end of the day, my objective is to convince the honorable court. That is where I have to go, and I have to make sure that, since we are guide to the court is like, I consider code as a layman, because they are not too scientifically inclined towards the scientific aspects of this science. So it is our duty to make sure that whatever we demonstrate, it should be backed with cogent reasons. Uh, I should be having enough material, enough demonstrations, enough scientific quotes from scientific authorities, excerpts from their books, uh, which are trying to convince the court, first of all, and also back my observation. So if I have an observation to make, it needs to have a scientific backing. I just cannot claim anything just because under section 39 I'm an expert, I'm a trained and specialized expert. Doesn't mean that whatever I write, uh, court would agree to that. And you must be knowing that most of the people, they say that it's an advisory opinion. It's not a binding opinion. But I feel that if an expert, it depends on entirely on the expert, what quality of work an expert is providing, what demonstrations an expert is making, how the expert is making sure that if I'm saying it's a case of forgery, uh, you know uh, if I'm able to show those particular lines on which I am claiming that it's a forced signature, and if I'm able to convince the honorable court, then I think that is something which is important. I might be claiming a lot of things. From Akanksha, okay, sir, expert opinions are not conclusive proofs and the court has the final discretion. Uh, yeah, I agree. They are not conclusive, but as I said a little while earlier, that there are few exceptions in handwriting expert opinions, few cases of forgeries, whereby if it depends on the demonstration, because science is something which is ubiquitous, which is omnipresent, everybody agrees to certain principles. So in cases of trace forgery, suppose for example, if there are two different signatures which are replicas of each other, now two signatures are there and they are not showing any natural variations. So you feel that or maybe more than two, at times more than maybe 10 signatures are there, and it appears that you are looking at only one signature 10 times, it appears to you, because it is so like mathematically they look very similar. So in such cases, handwriting expert opinion is conclusive, provided the expert has demonstrated his findings in a much better way. Also, there's a saying, and there's a scientific reasoning also, that nature never repeats itself twice. So based on this quote, based on this axiom, this is certain, this particular aspect about trace forgery, that no two signatures can be mathematically similar. So all the people who are here right now, I can assure you this thing, that if you have a copy and a pen in front of you or a blank sheet of paper, you may please try to sign 10 times or 12 times or 50 times or 100 times, and you just show me two signatures which are exact replicas of each other. It cannot be, and it's a challenge. Nobody can do it unless and until you do any trick or something like that. I'm talking about a natural instinct of signing a genuine signature. So no two genuine signatures will ever be replicas of each other. So and court accepts this fact. There was a case law, Murarilal versus state of MP. If you go by this case law, if you go through this case, so it was held that handwriting expert opinion is admissible, and an expert, and it does not need any corroboration if expert has internally corroborated the findings. So corroboration is necessary at times, I agree, and but there are few internal findings whereby the if the expert has uh, uh, was able to convince the honorable court by giving all the suitable reasons, all the suitable, and we have always authorities also to quote. So we, whenever I'm opining, I am quoting at least 8 to 10 authorities, their books, their page numbers, whereby they have also accepted this particular thing, and why, and how does it affect my opinion, and how does it relate to my findings, and then the final conclusion is made. So yes, most of the time people say it is not conclusive, but again, it's a very subjective thing, depends on the signature and the problem at hand. Sir, I have a question regarding the scientific
Guys, seems like a power disconnect. Just wait for some time, so we'll be live soon. Thank you so much. Please be there. Meanwhile, the sir has asked to be ready with the questions and doubts that you have in the queue while the Wi-Fi connects back with him and he can join with you all. So please keep your questions framed.
Am I audible?
Yes, sir.
Okay. Sorry about the interruption. There was a power interruption. So I think where were we? Sorry, there was some question I was answering. I think. Can you please repeat that question once again?
The last
Uh,
question, like in situations where the forensic document examiner's opinion conflicts with the court's own prima facie assessment of a document, do Indian courts
Sorry,
generally,
can you come again? Sorry.
in situations where the forensic document examiner's opinion
Hmm.
conflicts with the court's own prima facie assessment of a document, do Indian courts generally balance expert testimony with judicial discretion?
Let's see. Again, as I said, there is always a conflict. Whenever a court finds an expert, since expert opinion under Section 39, it is taken as an advisory opinion. So there are most of the times what happens is that we have two parties, and each party is allowed to bring their own handwriting expert. Right. So one party has an expert which says that the document is a genuine document. The other party says the obviously the opposite. He would say that the signature is forged. So then court is in a dilemma as to, since both the parties are claiming the respective both, one party is saying it's genuine, one party is saying forged. So then court has the power under Section 73. They can take their own opinion, they can finalize their own decision, but they can either not believe either of the experts, or they would have to see which expert has given a more scientific and a more balanced opinion, which has touched upon not only about the facts whether a signature is genuine, not only whether it's genuine, but also they have ruled out the evidences of forgery, because this is some a weak link, I would say, in the testimony in India, that most of the experts, they are just giving superficial opinion. And I'll come to that. What exactly is a superficial opinion? So suppose if there is a client, and they say that, sir, we suspect that these signatures are forged. So there are few experts who I've seen over the past. They just jump to the conclusion. They just jump right away to the conclusion the signatures were not found to be written by the same person. And if you look at their opinions, they are not uh, you know uh, scientifically detailed opinions. There's just a formality that has been done. Three or four aspects have been touched upon, and that too without any demonstrations have been made. So they just put signatures. They don't even take photographs of the disputed documents. They just scan the document, and they crop those signatures and they paste it in their opinion. So such uh, incomplete opinions, they are not giving any scientific criteria whereby an expert has opined something, but he has not given the reasoning which is proper. Now there is another expert who has given, suppose if this same case goes to that expert, so that expert will not jump to a conclusion, but that expert is going to try to figure out, first of all, try to conduct prima facie whether all these things are there and or not. So if okay, my client says that these are forged, I might be convinced with my client, but first of all I have to make sure whether whatever my client claims is correct or not. So I have to undergo my own analysis, and it might happen that I end up giving a report which is against my client, but it should not be against the science. So and that is the reason for us also, we don't take each and every case, because whenever a client comes to us and they ask us they ask for a verbal opinion, sir, please let us know whether these are genuine or not. So we tell them that, sir, these are genuine. If he wants it, I wanted an opinion which says these are actually forged, so we refrain from giving such an evidence. Why? Because there is no point. I cannot go against the science, and that's the major difference in such opinions. So challenge comes before the honorable court when there are two same kind of experts. Both the experts have jumped to a conclusion. Both the experts don't have a scientific explanation to their findings. Court would not, and if court is not convinced with either of them, they can court has the power. They can uh, give their own judgment, they can give their own findings, and they can make both these opinions null and void also. They will not consider both the opinions. It's up to the court. I don't know, have I answered the question? Sorry.
Sir, I have a question. May I ask?
Yeah, please. What's your good name? Sorry, please tell your names also. Hello.
Hello, can you hear me, sir?
Yeah, I can hear you now. Please tell me your good
Good.
name.
Amir Abbas. Good morning,
Yes,
sir.
Mr. Amir. Please tell. Good morning, Amir.
Sir, I have a question regarding property dispute, sir. Let's suppose
Property
the
disputes.
father had executed and signed document transferring his self-acquired property in favor of
Hmm.
one of his son. Okay, both the
Okay.
parents passed away around the year 2007 or 8. Okay,
Hmm.
after their demise, the other son has now raised a claim alleging that the father's signatures on the property documents is forged.
Hmm.
In such a situation, what legal safeguards or remedies are available to protect the validity of transfer? Further, how can we defend ourselves at such kind of situation if we face? So,
Uh, See, Amir, the thing is that you have two different sets of documents. Now, the father and mother have made this property in favor of one son, right?
absolutely, sir. And that's the
And
property
and
is
other son
self-acquired
is denying.
property.
It's self-acquired property, and the other son is denying it.
Absolutely, yes, yes. On the ground of the signature on the property document is forged.
So he's saying, he's claiming that the signatures on the property that was given to one son, the signatures are forged, right?
Absolutely, yes.
So we can obviously go for an examination, and if the other son is challenging that, so the document needs to be examined forensically, and an expert would definitely determine whether the signatures are genuine or not. And more than anything else, also the chain of custody has to be maintained, although there are different circumstantial evidences as well. What led to this particular thing? How did the parents make it? Which year was it? And do we have sufficient exemplars? Do we have sufficient signatures from which we can compare this document? So it entirely focuses on, since the dispute is there, the admission denial has been done. So definitely we are going to conduct a forensic examination of those signatures, whereby we are going to find out whether the claims are correct or not, whether the claims are in place or not, whether there is any ambiguity regarding those signatures, whether the signatures are forged or not. And not only that, now, since I said the signatures are forged or not, there is a very important aspect, and I'm glad that you have asked this question, because what happens most of the times is, uh, whenever parents they make such documents, or when a will is made, most of the times the testators they are from the age group of 55 to 65. So when a person has passed a certain age, and when I'm saying certain age, I mean more than 55 or 60, and that is the period around which people they make their wills, or property transactions. So the muscles of their hands they become weak with age. So the signatures they tend to become a bit shaky. So people they some experts, I would also say, they misrepresent those signatures, or they get confused. I would say rather they get confused, or they are unable to identify. And there are the tremors found in those genuine signatures are because of tremors due to old age. So when we are old, 55 to 65 years of age, or 75 years old, we are unable to hold a pen in proper reasons. The muscles become weak, being the primary reason. Secondly, it is also most of the cases it is like, uh, since we don't most of the people they are not into the habit of writing on a daily basis. So even if a person is highly literate, if a person is the hand muscle is also working properly, but he might not be writing on a regular basis, on a daily basis. And if you ask that person to sign on 5 or 6 documents, or 5 to 6 times in a document, the signature might appear a bit shaky. But that doesn't mean the signatures are forged. So the tremors due to old age versus the tremors due to forgery, these are two different kinds of tremors. So, an expert needs to identify whether the tremors are due to old age or whether the tremors are due to forgery. And this is the primary reason why people they challenge those documents, because they say these are not my, and they compare those signatures with the ones which are 10 years back, taken 10 years back or 20 years back. So what happens is that you are basically comparing two sets of documents with having two signatures which are belonging to different time periods, though they might be of the same person, but there is a signature belonging to the person's age when he was 45. Then you have a disputed signature on a property transaction which is, say, when he was 65. So it's a 20-year gap. So there are going to be variations. 45 साल की उम्र में जो साइन होगा, that is not going to be the same as in 65. And that holds well with each one of us. अगर हम लोग भी अपने 20 साल पुराने साइन देखेंगे, so there is going to be a remarkable difference, but that doesn't mean the signatures are forged. So in such cases, Amir, uh, I would say emphasis is laid much on identifying if there are tremors or not. If there are tremors, then first of all rule out whether the tremors are due to old age or whether the tremors are due to forgery, and then we can go ahead. If the tremors are due to old age, then we would be comparing it with other contemporaneous signatures. We would require a lot of signatures, and that's again a big headache for any expert, for any advocate also, to decipher such signatures, to look for such signatures, to procure such signatures, because we not in a habit of signing on a daily basis. So it becomes difficult, and we can look for some specialized signatures, as in bank documents or affidavits or some property transactions that have been done in the past. And if not, then it becomes a difficult scenario. Okay, I can see. Thank you, Amir. Then again, Gaurang has asked something. Sorry, I'll just check it. Mr. Gaurang Singh has asked me, do you think India needs some more standardized scientific framework evaluating process documents? Absolutely correct, Gaurang. Thank you for this question. And I think, yes, it's the right time that we need a more standardized scientific framework, as in European countries, in America also. If you'll go, there are different standards that are in place. There's a Daubert and Fry method. Then there is ACEV, analysis, comparison, evaluation, and verification method, uh, which is, I think, the right way of doing it. And to be very honest, I don't know whether most of you might not have seen our report. Obviously, I think none of you must have seen the way we write. In our opinions, we don't mention though ACEV or Dovert and Fry, but our reports, they contain all the standardized scientific frameworks, because that is something which is essential for any expert. Uh, See, at the end of the day, I have to be very honest with myself. I just cannot write any opinion just to make my client happy. It's okay. A lot of our opinions might be in favor of our clients, which is fine, which is very good. But then there is a certain duty for of every expert to make sure that because we are not writing opinions just for the mere reason of writing an opinion, just for the sake of it. uh, a very important aspect is the cross examination, and which all of you must be aware. Cross examination is something which brings out the lacunas, or if there is any shortcut, or if there is any cut, copy, paste, or if there is any unscientific or biased approach in a report. So that cross examination, it tends to like give holes in your opinion. And we are very much aware about the cross examination, so we know that if we, even if we give a casual or substandard opinion or a foot in the door kind of an opinion, whereby we have not touched upon various aspects, we are just talking about uh, a certain class and individual characteristics, and which is quite superficial, which is present in each and every opinion, but again it does not connect the dots together in the opinion. So it again becomes a very superficial opinion without any cogent reason. So we don't do that. So we follow our standardized scientific framework, and that's the reason our reports uh, they go all over the world. We have opined for various countries, various law courts, whether it's Malaysia, Singapore, Mauritius, UK, US. Everywhere our opinions have gone, and that is why they consider, because they know that we don't uh, I would say compromise on the way we present our, and it becomes quite tedious for us also, because at the end of the day it is just a you can say a advisory opinion, but it is not so. It should not be taken so lightly that since it's an advisory opinion, so I can give anything that comes to my head. I just put it because I have the power under Section 39. I can give my opinion. Opinion has to follow a standardized scientific framework, and I think India definitely needs this in place. Section 39 is fine, but an expert needs to be grilled in and out during cross examination. Uh, Another question, Abrar's question is there. What modern technologies are commonly used today to detect document forgery? Abrar, thank you for your question, first of all. Modern technologies, see, I can boast about entire paraphernalia. I can talk about n number of machines. I can talk about n number of microscopes. I have this particular machine at my office. I have this particular equipment or apparatus in my lab. But uh, it depends on the expert's eye, whether the expert has the eye for detail or not. And there are experts who have the entire paraphernalia with them, but if you ask them a simple question, they are going to give you a very circular answer to that question. They are not going to be straightforward with you, because they might feel that I'm not convinced. So yes, it is good that if you have a good magnifying glass, if you have a good microscope, if you have a good camera, if you have a good light with you, if you have good certain other scientific instruments with you, but even if you have the most basic equipments with you, it is not an impediment in your observation. You can understand this thing. It can always enhance your findings. It can maybe a 2 or 3 degrees deeper. You can delve into it in a much more deeper way. But having said that, even if you have the most basic equipments with you, most basic apparatus with you, uh, I think it is always the expert's eye and expert's experience. How has he particularly concluded that opinion, and how has he reached to that conclusion? So एग्जैक्टली ऐसा कोई टेक्नोलॉजी नहीं है कोई बहुत कॉमनली. अगर हमारे पास एक मैग्नीफाइंग ग्लास भी है अच्छा, and we have good light source, and if we have taken good photographs, if we have taken detailed and enlarged photographs, I think that is sufficient. Any other question, please? Okay, it's sorry, it's Laina Chaudhary. Sir, if signatures are made digitally, can forensic document examiners also examine them? If yes, then how the examination is conducted? Like you explained that for handwritten signature on paper, techniques like convert like ठीक है. So how is forensic examination carried out in the case of digital documents? Okay, thanks Laina for your question. If signatures are made digitally, again it's something which is very much in place these days. A lot of cases are happening all over the world, and you'll be surprised. Every other signature is a digital signature these days, and if a signature is made digitally, uh, No, no. Since you have asked me digital, I'm thinking about the signature which are on the PDF documents. Correct? Am I correct? Or you're talking about some other format? Because with digital signatures that are coming to us, most of the companies, what they do is, when we are dealing with NCLT cases, uh, people, they have made the stamps of their signatures, or because they have to sign on a daily basis on more than 100 or 200 documents. So what they do is they just paste their signatures everywhere. Problem arises when company is not dealing with such such a uh, I would say practice, where the signatures are cut, copy pasted, or digital signatures are made. So in such cases, what happens is that photography and analysis, in such cases, I want to first of all see what is the problem, whether the signatures have been transplanted on a document by some software such as Photoshop. And if that is the case, then in computer transplantations, uh, there is no natural variation. So if I have a signature, uh, I have done a signature, I'm working in a company, and I have been in the company for last 10 years, suppose. And there is one signature, there is a document, one of my document which is in company's profile. Somebody, what he did was, he picked that signature, he lifted that signature from by some software, and he implanted or transplanted that signature on another document, which is again a soft copy, and then he took a print of that signature. Now what has happened here is, he has picked my actual signature from a document. The signatures are not manually traced, they are computer transplanted. In such signatures, the major challenge for an examiner is, if the examiner is able to find out the source of that signature. For example, if I'm examining that signature which is transplanted, and if this document comes to me, uh, the person provides me all his genuine signatures, and if I find this particular signature amongst the admitted comparatives, then I can see, and I'll conduct an inter-se comparison between these two signatures, and I will find that this is the actual signature which has been transplanted here. Now, why am I saying so? Because it is not showing any natural variation, whereas all the other signatures are showing natural variations. The signature is slightly ascending, descending, rotated, you know the spacing between the letters is different, or the size and proportion of individual letters are different, the alignment or slant is slightly different. But in this particular signature, there is nothing like that. It is absolutely a replica, and we conduct 3 or 4 different tests to identify such signatures. So yes, in such on such documents, we cannot conduct a transmitted light unless and until we have the originals. And obviously, you are right. In case if it's a computer transplanted signature, there is not going to be the original of the document, because on original you cannot transplant. So what least they can do, what maximum they can do is, they can give a colored copy of the disputed document. So in such whereby in such documents where we don't have the originals, we have different methods that we do, and different scientific principles that are applied. So yes, those are some of the cases that are coming to us mostly these days. Uh, Next question. Sir, should forensic document examination in India move towards mandatory peer review of expert? Very good. Thank you, Gaurang. Mandatory peer review of expert report before they are presented to court to reduce the possibility of subjective interpretation. Yes. When you say subjective interpretation, I would also say contextual bias. And if see, I believe on this simple principle, and this is for all the advocates, all the upcoming lawyers also, that if you are selecting any expert, don't go as per their representation which is happening through their social media pages, or their Instagram presence, or their Facebook presence, or their website. This That is fine. You'll get a fair idea about the expert. You'll get the qualification of the expert, the kind of work that expert is doing, his achievements, his judgments. You'll get to know all these things. But before assigning any expert, the first and foremost thing that any advocate must do, any client must do, is to have a pre-trial meeting, a pre-trial conference with the expert. Talk to that expert. Try to find out whether the expert is, what kind of strategy that expert has for this particular case in order to demonstrate it to the honorable court, in order to convince the honorable court, rather than just trying to, impress everybody that I have, these qualifications. I belong to this associations. I have worked for this client. This is fine, but always try to examine an expert. First of all, a pre-trial conference is a must. Talk to that expert and try to cross-examine him initially. I really feel overwhelmed when people, they cross-examine me and they cross-examine my findings, and that is something, we mostly, and most of the people, if somebody of you have taken opinion from us, they are aware of this thing. We don't charge anything for a verbal opinion. First of all, if anything, if any client comes to us, we never ask for any verbal fee, or a prima facie fee we need, or this kind of, and money needs to be deposited with us. Our major people, why they come to us is, they, first of all, this is my duty, basically, to make sure I don't make my client confused. If even if my findings are against my client, he needs to be aware about those findings, how convincing is his case, whether the objective that he aspires to achieve, whether that objective is scientific or not, whether that thing can be done or not, whatever he feels, or he thinks about the document. So I need to draw a correct picture in front of him, even if the client doesn't come to me, it's fine. But the thing is that this is my duty, that I need to make sure the client needs to be told the honest truth about the document. And this is something we practice mostly. Most of the clients, they don't come back again because the objective is not achieved for them. Koi baat nahi. But the thing is, I'm happy that I have given whatever peace of mind, whatever was there scientifically to be told. So yes, I agree that in India, mandatory, it should be mandatory, the peer review of expert report before they are presented to the court. And if we have time, I would like to once again like to talk about one of the cases that I did for Singapore International Commercial Court, whereby I was representing one of my clients. So what happened was, I like prepared an opinion, and I was cross-examined by the client, by their learned counsels, for more than 1.5 months. I was literally grilled in and out. But I was happy that I was able to defend all my findings, because reach I did not jump to any conclusion. I made it was a step-by-step analysis of the entire signatures. Whatever I opined, I had the scientific backing for that reasoning. So they could not find any loophole in my report. So I was very much happy with, because that's how we prepare for any such thing. And once you do that, then you can appear before any court, appear before any tribunal, and you would pass in flying colors, because you have done a very honest approach. You are very much scientific. You have not taken any shortcut. So this is a major thing that clients and the advocates need to do in terms of hiring handwriting experts, is talk it out, try to find out. And and most of the experts, they run away from talking to the clients or talking to the advocates. I don't know the reason for that, but I think because it's since everybody says it's not conclusive, it's an advisory opinion, so it's always advisable that you please talk, because you are definitely the he's going to charge his fees also for giving you an opinion, so he's answerable. So you need to it should be mandatory. The report should be reviewed before submitting, presenting it before the honorable court. Why not people use finger impressions on documents instead of signatures? Very good, thanks, Aman. Fingerprint science is more advanced and settled than, yeah, absolutely, Aman. Absolutely, very valid question. Why they are not using finger impressions on documents, though it's a pure science. But let me tell you again a very harsh truth, a harsh fact. In our country, people are not equipped uh, to take fingerprints in a correct manner. They don't know how to take thumb impression correctly, or take for fingerprints in a correct manner. When I say in a correct manner, I mean most of the thumb impressions that come to us, they are either smudged. When I say smudged, they are like a blot. वो एक धब्बा है, that's it. वो एक आकार में एक धब्बा है. There is no ridges visible in that. I cannot even find out which pattern is it. It is so bad in shape. Why? Because it is over inked. So what they do is they just put your thumb over a stamp pad like this, and then they put the document and they do it like this. So the pressure is at so much that there is a blot. Acha, they feel that the more you press, the better the print would come, but it doesn't work like that. Once again, so again, it's a useless print. Then if you don't put enough pressure also, you just put a light like this, then also the ridges are not visible correctly. Then there is another scenario whereby they just put a print, and they again put another print over that. So you have a print, you have taken a print twice. So it superimposes with each other. Again, the ridges are gone. So most of the time, thumb impressions, they are not taken properly. The correct way of taking a thumb impression is, and in one of our videos on Instagram, we have demonstrated that. It's an old video whereby we have told that you can see this portion, this nail bed is there. So your ink should be applied from this portion to till this portion. So this entire thing has to be covered with ink, and then you have to roll it like this. So you stand at the edge of the table, you have a document, and you put it like this. You don't put it like this. You just keep your finger like this and you roll it like this till the time from one end of this nail bed to other end of this nail bed, and that is called a rolled print. So now what does this rolled print do is, it gives you a wider analysis of your thumb impression. So it includes all the ridges from here, from this portion to this portion. So you have sufficient material uh, of ridges with you. So even if and the disputed signature, or sorry, the admitted signature, some portion is not visible. Whichever portion is visible, you can find out that exact location in this thumb impression. So you have enough and sufficient ridges with you to play around with. But mostly it is not. It doesn't is taken care of, and that is the reason why your question is that fingerprint science is more advanced. Why don't they use? I still feel that we have a long way to go uh, uh, in identifying thumb impressions as well, because the way people take thumb impressions in our country, it is not the correct way of doing it. And we also train people. We also train police departments. We also train. We have had this privilege of giving training to army judges. We have got this privilege of training to the judiciary members. We have told this thing to most of the people, and we keep on telling them, even the staff training colleges of various banks. So we tell them that these are a few practices that need to be uh, accepted. And I think the ratio, the case ratio will definitely go down if such basic steps are taken care of. I hope I've answered your question, Aman. I really have me challenge. Okay, thanks, Gaurang. I don't know whether I explained it in a better way or not. If I may ask from litigation perspective, since forensic document examination often involves a degree of subjective interpretation, what specific technique should a defending counsel use during cross examination to effectively challenge the reliability of a forensic document exam? Absolutely. I was looking for this question. Uh, since forensic document examination often involves a degree of subjective interpretation, तो डिफेंस काउंसिल क्या करे, कैसे पता लगाए कि ये ओपिनियन जो उसने दी है एक्सपर्ट ने, whether it is subjective or whether it is scientific? Again, the best way of doing is the cross examination. Cross examination के जरिए, but cross examination, having said that, uh, it is easier said than done. Cross examination doesn't mean that you just have a set of questions in front of you. I'll come to again to another story now, since you have asked this question, and this happened very recently. Uh, one of the I won't name anybody, obviously. So one of the counsel, he came to me and he said that, Manas, in this particular case, I need questions, and I have to cross-examine a particular witness. So I said, okay, no problem. So I went to the
Seems to be a power glitch, guys. Please be there. He will be right back. Thank you for your coordination and patience. He may join us soon within 2 to 3 minutes, guys.
Sorry again, once again for this interruption. Am I audible?
Yes, sir.
Okay, thank you. So I was discussing about this senior counsel. So one of the counsels, he asked me that, Manas, kindly provide some of the questions that we have to ask to a particular expert. So I I went to that. So he told me that you come to the court and you provide me the questions. So I said, sir, I can give you the questions, but it would be great if a SPA could be given to me, a special power of attorney, and if I should be allowed to ask questions, because and only an expert could question can prepare questions effectively, and he can cross examine another expert. So but unfortunately the SPA was not given to me for reasons I don't know. So the counsel Saab, he said that, Manas, you stay behind me. But again, the other counsel, he was he said that I cannot talk to the counsel. So he was on his own. I had given a list of I think 20-25 questions were there. Now what happened was, this is a major issue. Uh, that particular counsel, what he did was, although I like him a lot, what he did was, he asked question one. Now, answer that was provided by the witness, it was not at all convincing. Rather, it was an evasive answer, I would say. He was trying to run away from that question, and I noticed it on the spot. But then I was not allowed to speak to my counsel, and what he did was, my counsel, he jumped to another question. Now, this was a major defect in that cross examination, because I knew, being an expert, that this is not the right answer, or this is not a convincing answer, this is an evasive answer. I know it, but the counsel doesn't know at times. So, but I could not talk to him. So he jumped on to question number two, and the same thing happened for next 30-35 minutes. And एक बहुत अच्छा chance था, that was lost. And this is something which happens most of the times. So again, I think an expert should always cross examine other expert. There are different reasons why they don't do it. I know that, and I think you also are aware of this, why they don't do it, because an expert is giving an opinion in one party's favors, obviously. uh, I'll come to you, Amir. Just I'll come to you. So this thing happened, and a glorious chance of cross-examining that witness was gone. So this is again something which irks me, and I think I really feel helpless at during those junctures, because I know that what he's trying to come at, and why is he evading, evasing, giving an evasive answer. So that thing needs to come across. So I told my learned counsel that next time onwards, sir, you make sure, and then there are no suggestions also in place. So it is just like you are asking a question and then an answer, then a question, then an answer. So it is not leading you anywhere. Your cross examination will take place, but then there is nobody who could find out whether the correct way of cross examination was done or not. And court is definitely going to see the final the set of questions or the technical arguments that are made towards the end. So that's a lacuna that I feel, that since the councils are not forensically qualified, they are not aware about the question documents. So it's always better an expert should ask the questions, because even if I give n number of questions to anybody, it is not sure that whether it is going to be conducted in that flow or not. Because if suppose I have given question numbers 3, 4, 5, 6, but after the answer given to question number 3 by the witness, it is imperative that I ask question 7 now rather than question 4 in that order. So I, as an expert, I know that I need to change and reshuffle my questions now, since these two questions have already been answered. So if I ask them again, it's not going to serve any purpose. So I'm only damaging my cross. So that has to be taken care of. So that thing really happened, and I don't know which question I was answering. Sorry, I've lost on question. Whose question was it? And exactly what was the question? Sorry, I lost it. Should I move on to next question? Okay. Amir Abbas. Forensic reports sometimes take months or even years. Courts often wait for forensic confirmation of signatures or documents. By the time if the report is delayed, the accused may remain under investigation or trial for a long time, affecting their liberty and reputation, which affects Article 21. Absolutely. which talks about speedy trial. With such long delays, witness may become unavailable, memories fade, documents may deteriorate, which indirectly weakens the faith and nation. How do you see all this, sir? Or what precautionary measure we could take to avoid all these issues? Yes, I absolutely agree with you. Whatever you just mentioned, Amir. I think it's loss of valuable time, loss of the justice being served. So many things are affected. We also get affected. Councils also get affected, and memories fade. Uh, what energy I have right now talking to you people, I might not have the same energy in the evening, or I might not have the same energy next morning. Right? I might be busy somewhere. So whatever I am doing right now, uh, I have the same zeal, I have the same enthusiasm, and I think if that is being delayed for a later period or very late period, maybe years or maybe months later, it is not going to. It is definitely going to weaken the final result or the judgment for that matter. So yes, and now if you're talking about take months or even years, see, private expert reports, they don't take much time. I think even if by any standard, I don't think so. It is going to take more than 2 to 3 weeks. Any private expert report also, even if the volume it is highly voluminous. But I think you're talking about the FSL, the state forensic labs. Yes, I agree. They take they sometimes take months, they sometimes take years also, and which is wastage of time also. I feel that uh, things, they don't look so deceptive on the surface, that we have to wait for 2 to 3 years to basically to give a justice to the clients. So I think your question says that how do you or what precautionary measure we could take to avoid all these issues. Precautionary measures, see, the best thing is that we can have fast track courts. Arbitration matters bhi hain. So even I think we need to have such some bodies who could actually try to accelerate the procedure, try to, because in such cases whereby I'm still waiting for some of my judgments, and I gave opinion 3 years back, still the case is running, and every other month there is a date or something happens, and those were not so आई वुड से इतने बड़े केसेस नहीं थे वो, जिनका जिनका यू नो रिजल्ट आने में 3 से 4 साल लग जाए. Still the cases are going on, and I have lost count on some cases. I even don't remember कौन सी कोर्ट थी, कौन से क्लाइंट थे, क्या केस था, कौन सी पार्टी थी. आई डोंट. एक दो केसेस में तो ये भी होता है कि वी आर समन्ड बाय द कोर्ट, वी डोंट नो, uh, uh, because our party, the client which engaged us, he or she is nowhere to be seen. The only counsels they appear. So हमारी fees भी चली जाती है. We don't know. Then we have to ask the honorable court कि sir kindly we don't know, ये 10 साल पुराना केस है, 13 साल पुराना केस है. So it is a big impediment, and I think something needs to be done to control this. Absolutely. Yes, you're right. State Forensic Lab, Central Forensic Lab. Okay, so consider that forensic documentation often relies on qualitative comparison rather than quantified statistical models. Do you think the future of this field lies in developing large-scale handwriting databases and machine learning-based validation systems to objective? No, Gaurang, it can happen for thumb impressions. It can happen for blood, DNA, and other things, serum maybe. But as far as handwriting goes, I don't think so. Any such large scale databases or machine learning based validation systems would be handy and would help us to serve that purpose, because for the only reason, it's a neuromuscular act. Handwriting is the only science which has variable factor. That means that if I sign in the morning, if I sign midnight, if I sign next morning, if I sign next month, if I sign next year, every sign is going to show variable differences. The signatures are going to vary a lot. Machine cannot decipher, cannot even reach close to that range of natural variation. A natural variation could happen. I cannot decipher what exactly is going to be my range for next 10 years. And there are so many external and internal factors also involved, because if I'm signing on a smooth surface, I've kept a paper on a smooth surface, my signs are going to be different. If I am signing on a surface which is rough, which is maybe a wall or maybe a rough surface, my signature is going to get impact. There's going to be an impact on my signatures. If I am standing and I'm signing, the impact is different. If I am traveling in a car, or I'm taking a flight and I'm signing midway or midair, that also my signs are going to change. If I am intoxicated, if I'm having something and I'm not very conscious, my sign are going to be different. I might be having some disease in my limb, like Parkinson is there, or some other neuromuscular disorder is there. I might not be able to hold a pen. I might be uh, welding something. I might be working on some different instrument, and I hurt my finger or hurt my nail. I am not able to hold it. I'm wearing a band-aid. So all these factors come into existence. So no machine, and I again repeat it, no machine or no, as you mentioned in your question, large scale handwriting databases or machine learning based validation systems. No, I don't think so. It can happen. Even if it happens, even if there is any, if somebody claims that he has devised a machine that could identify signatures, or which could differentiate between a forged and a genuine signature, I will never trust that machine, because the natural variation, the science of natural variation, and no machine is able to find out. Now again, I am going to give you another example, and for that I don't even need machine. Also, you must have seen, if you go to any bank, right, there are people who are validating your signatures. So you have a specimen in your bank, and there is a check that bears your signature. The signatures in the bank that you have given as a specimen, they were in the year 2008, for example. And then there is a check whereby you have signed a check, and the signature happened in the year 2020, suppose 12 years later. So obviously it is going to show remarkable variation. The person sitting on that chair inside the bank, he is going to look at your check like this, and then he's going to look at the specimen given by you in the year 2008. So there is a gap of 12 years, right? So he's going to look at your signature, he's going to look at the signature on the screen, and then he would say, he'll give you a call. He would say, sir, your signatures are not matching, right? So, and this must have happened with so many of you. It happens with me all the time. So I go to the bank, I give my current specimen, and then they say, okay, sir, now I validate your signature, which is fine. Now, go to the same bank, just do nothing. I'll tell you, you pick up any signature. आपका जो 2008 का सिग्नेचर है, जो आपने स्पेसिमेन में दिया हुआ है बैंक, you have a photocopy of that signature with you, suppose, right? आप उस सिग्नेचर को एक चेक पे रखिए, नीचे लाइट लगाइए, and you trace that signature. Somebody trace it. No, you don't trace it, obviously, you will not forge it. Somebody else does it. A perpetrator, a forger, उसने आपके 2008 के बैंक वाले स्पेसिमेन लिए, एंड ही पुट इट अंडर अ डॉक्यूमेंट, लाइट लगाई ट्रेसिंग के लिए. I hope you know what is manual tracing. And then he traces that signature over a check. You'll be surprised. The bank, the same person would clear that check. Why while he do that? Why? Because वो उस चेक को देखेगा और वो स्पेसिमेन को देखेगा, he would say, यार ये तो सेम है, यानी कि एक ही आदमी द्वारा किए गए. So they don't consider the signs of natural variation. They only look for the shape of the signatures. Anybody can make a replica of your signature by trace forgery, but that doesn't mean the signature is genuine. Only an expert would be able to find it out. So there were a few cases in one of the banks, one of the leading private banks in India. So they approached us for 27 such cases. There were 27 such cases from one bank only over a period of 1.5 years. And most of them were traced. Most of them had picked loans from the bank whereby the person did not even exist and his signatures were there, and the bank had passed the loan. So all the loan officers, had to they were thrown from the chairs, because maybe they were the parties they helped the perpetrators in doing that forgery, whatever the reason. There were so many people who were thrown out of the bank because of this small mistake. So this is a very small example, and that is the sole reason why machine learning based validation systems can never happen. And I'm not talking only about India, I'm talking about the entire world. Signature analysis can only happen with a manual expert. If you take an AI or any machine based validation system, 8 out of 10 times it is going to show the wrong results. Trust me on this. I hope I've answered Gaurang's question. Sir, generally in, okay, whose question is this? Sai Lakshmi. Okay. Sir, generally in crime scene investigation competitions, okay, the procedure involves gathering of evidences from the crime scene, followed by the analysis of the gathered evidence, and finally the preparation of a conclusive report on the basis of the gathered evidence. So, being a forensic expert, could you please guide us on how to approach each step, each step in brief? Uh, with the crime scene, I think you are talking about any murder scene, or because there are so many things happening in various universities. They prepare crime scenes. They show that there is a dead body. Then there are different evidences. There वो कांच टूटा हुआ कांच पड़ा हुआ है, blood के fragments, and then DNA samples, बाल के कुछ रेशे पाए गए, नाखून पाए गए, या क्लॉथ का कुछ पाया गया. एंड यू मस्ट बी टॉकिंग अबाउट लोकार्ट्स प्रिंसिपल ऑफ म्यूचुअल एक्सचेंज, कि जो भी इंसान आएगा वो अपना कुछ छोड़ के जाएगा और वहां से क्राइम सीन से कुछ लेके जाएगा. सो कुड यू प्लीज गाइड अस ऑन हाउ टू अप्रोच ईच स्टेप? अप्रोच का देखिए, साई आपको एक बात मैं बताऊं. आई हैव बीन प्रैक्टिसिंग इन द कोर्ट्स फॉर लास्ट 18-19 years, and it's a fun activity in competitions. It's a fun activity in colleges, but to be very honest, it does not happen the way they show it. And I'm not naming any university. I'm talking about each and every university. This is something. वो जैसा वो होता है, वो सीआईडी आता है, सोनी टीवी पे एक सीआईडी करके शो आता था. So they show, that if you put this chemical inside this test tube, it would change green, and if you put this thing on a dead body, it would show whether he was, it's a homicide or it's a suicide. These things are shown in a uh, different manner, but it doesn't happen that way. Real analysis, real investigation is there is no glorification in reality. So on how to approach, see again, how to approach each and every step. Obviously, if there is a murder happened, you have to first of all preserve the crime scene, and which never happens, unfortunately. It cannot happen actually. Preservation of crime scene, even if some of like any of the closed one is like, if somebody committed suicide, for example. So whomsoever is the first person to see that person hanging, the first impulse would be to bring him down. So he would have definitely, not him. He would take him down. He would try to find out whether he's awake, whether, sorry, he's alive or not, right? So that is the first impulse, first reflex that you do. So if you and it's very rare that people, they don't touch it, they stay away, they lock the door, they don't let anybody go inside the room. It happens not always. It does, like ज़्यादातर नहीं होता वो. So let us be very realistic about it. So preservation of crime scene. So जब आपने उसका फंदा खोला, उसको लिटाया, तो उस प्रोसेस में ही आपका क्राइम सीन खराब हो गया. जब आपने उसको खोला होगा, तो थम जो जो पंखा है जिससे वो लटका है, या किसी चीज से भी जो जिसपे उसने फांसी लगाई, वो वहां पे फिंगरप्रिंट्स हो सकते थे. अगर उसको मार के लटकाया गया है तो उसके थंब इम्प्रेशन हो सकते थे. तो आपने उसको छू दिया, वो खत्म हो गया. वॉल पे आपने हाथ रखा, आपका आपका एविडेंस जा रहा है. Each and every second you are losing on evidence, right? So yes, there are different approaches that you can take, and there's a different. Obviously, you will go for a post-mortem report would happen. Then you would also go for, if there is any DNA can be extracted from any of the samples lying around. If the blood samples are found matching with the same guy, or if somebody else was there in the room, or if there any latent fingerprints are there on the wall, if somebody came, if something has been lost, if a burglary has taken place, something like that. So you are going to take care of all these things. But again, I would say that it's not a foolproof thing, and it does not happen that way. So answering this question, I think, would not be. I would say that it has a very subjective interpretation to it. So step by step, I don't think so. How are you going to approach it? It depends on, again, it's a subjective question, depends on the situation. Sorry, depends on the situation, depends on the current scenario, what has happened, what degree of crime has taken place, which degree of crime has taken place, what exactly has happened. So it depends. It's a slightly subjective question to ask. I hope I have tried to make sense in whatever I just mentioned. So, do you think there should be a global scientific standard for forensic? So, court psychologists can rely on more informable. Uh, Again, Gaurang, I think I've already answered this question. Uh, See, all over the world, there is a certain standard which is maintained. As I also mentioned about Dobbert and Fried method, then there's ACEV methodology which is adopted. At the end of the day, in India, I'm only going to talk about India. Yes, your question asks about the global scientific standard, but I would say that two things. First of all, in signatures and handwriting, the variable factor makes it almost impossible, for to select the methodology. Methodology is primary. What methodology? When I say methodology, I mean whether or not, if I say the signatures are forged, so I should first rule out every iota or sign of genuineness in that signature. If I am unable to rule out any sign of genuineness, I cannot say that document is forged. If I'm able to prove that, no, yes, there is not a single iota of doubt, there is not a single thing that on which I would base my opinion on, or I would say that signatures are genuine, then only I can go for a forgery theory. So methodology, again, it's a subjective thing, depends from expert to expert. It is not necessary that what methodology I adopt, other expert also adopts. And when I'm talking about other expert, I'm talking about global. I'm not talking about only about India. I have seen various experts across the world. They have cross-examined me. I have cross-examined them. So I feel that and I was surprised, literally surprised, in one of the cases whereby I was expecting that expert to at least should that expert should have done at least that particular methodology must have been adopted by her in one of the cases. But I was surprised, and she was an international expert outside India. But I was surprised that the kind of work that we are doing, it's something that they are not doing. They are basically more subjective in their analysis. They are not giving sufficient reasoning, and they are relying more on the experience that they say that I am from a government structure, and so my opinion holds more significance. Things like that. So since document examination, we are talking about variable factors, so it is difficult to resort to one particular methodology. It cannot happen. It can happen for thumb impressions. It can happen for other branches in forensic, but not for uh, signatures. Okay. Any other question, please?
Right, so we move towards the conclusion of the session. So here are a few very minute questions asked by the students for you. So
Mm-hmm.
basically, can you put up some light on data forging nowadays? Because the technology is moving forward on the digital landscape today.
Mm.
So can we just have some information related to data forging? And also the second question lies here is that is it possible that the government can come up with the digital examination skills related to forgery in future as per we see? And also, if the time permits, can you just put up some light on the cloud storage related to the storage of the different documents which are required as per the digital aspects? For
Mm.
example, in the earlier evidence, Indian Evidence Act 1872, as we can see, first the evidences were collected and kept for long. So the corrosion things used to happen, but it used to be stored. Now the things are very pretty much different. So can you just put up some lights related to the cloud transformation and cloud storage related to this?
Okay,
So
Soumya, which was your first question? Sorry.
my first question is related to putting up in your detailed insights, if any, on data forgery nowadays, because the data manipulation can happen at any time. Because today we live in the world of data in all the forms.
Mm.
So data forgery.
Yes. So let us go step by step. Data forgery. Now, when we say data, it could be anything. It could be a piece of photograph. It could be, your account details. It could be your signatures, obviously, your thumb impressions, your uh, other identities could be. So, see, we are living in such a world whereby it is very difficult to monitor each and every detail or each and every information that comes to us, or we reach out to any information. So, for example, if even if we order something online, so we are vulnerable. We are giving all our details, and this happens all the time with most of the apps that we download in our mobile phone. So when once you download anything, it says that some of your data would be given to that particular app or the service provider, whatever it is. So and we don't care about it, to be honest. We just put yes and we put a tick and then we move on. But what I actually feel is that whatever is being said, whatever is, even if I'm sitting in a closed room and I'm talking to myself, even that is something which is monitored by something. And the biggest culprit is your mobile phone, because whatever you say today, it goes somewhere. We don't know where and who manipulates it or who uses it at for his own benefit. We don't know. We cannot say, but it is happening. So data forgery has increased considerably over the years. There are people who are coming to us with photography. They have photographs to compare. With the advent of AI now, it's very difficult to. You must have seen. I myself am using so many apps also whereby I'm making AI videos. So it becomes, the line between the reality and fiction, it is so thin today, it is impossible. And with having said that, the duty of every expert has increased threefold, tenfold even, I would say. I cannot today, and I don't take most of the cases pertaining to where there is a uh, photograph which is in question. They say, sir, this he is not my father. See, I have got this photocopy, and this is not my father. See, sir, he does not have this. His forehead is not that broad. His nose is not that long. Sir, इसके देखिए सर में बाल भी कम है. मेरे father के ऐसे नहीं थे. I don't think, because it is very easy for anybody to say anything, and just on the basis of uh, you know superficial difference, or on the surface, I would say, I cannot say that is going to be my subjective interpretation about something. If I'm talking about a photocopy, even on the originals, I don't think so. If an expert is opining on photographs or any video, it is very easy to manipulate these days, and the line has become very thin between reality and fiction. You cannot determine, and if in case if you are uh, opining on something, if you are giving your conclusion, you better have the scientific reasoning to it, so that you don't create a mockery of yourself inside the courtroom. It should not look as if I'm giving my subjective interpretation about a particular thing. It should be convincing, and that is why I don't. Earlier I used to give opinions on photographs also, whether the two people involved on this the photographs, whether they belong to the same person or not, or whether there is a CCTV footage, so find out whether there is any tampering with that CCTV footage or not. No, I don't take those cases anymore. The primary reason is that I don't have the time, first of all. Secondly, because once there is any software involved, or it becomes very difficult to, and with each passing day, right now we are talking, it's been almost 1.5 hours. इतनी देर में भी 5 या 6 अलग अलग सॉफ्टवेयर बन गए होंगे कि जो डेटा को इंटरप्रेट करने के लिए या मिस इंटरप्रेट करने के लिए बनाए जा रहे होंगे. सो इट बिकम्स डिफिकल्ट. सो Yes, data forgery, you have to be very specific which data are we talking about. I'm only talking about those data जिसके लिए मैं opine करता हूँ. I'm not talking about any other aspect, because I am mostly involved with documents, and photographs and videos are also a part of documents only. So I'm only going to talk about that. And yes, with data forgery is definitely in all time high. uh, I'm very scared. I don't put anything on social media pertaining to my family. I don't put my family photographs. I don't put any personal information on any social platform. All I do is I there are my work related videos or forensic related videos which I try to make sure that reach out to people. That's the only thing that we share. Otherwise, we don't share any personal information, and all these things are at all time high. I keep getting these calls every other day that, sir, you have not given such and such bill, you have made a small mistake. You need to we are coming to remove your connection, we are coming to remove your this and that. So I tell them, please come and talk to me. मैं एड्रेस भी क्यों दूं उनको, आपके पास तो एड्रेस है, प्लीज कम एंड टॉक टू मी डायरेक्टली. So I don't spend too much time over that, because I don't know who that person is, from which area he or he's talking. एक बार मेरे को कॉल आया by some police officer, and I was sitting with my father only, and call was made on to my father, and he said that your son is with me right now. Police officer saying to my father that your son has been arrested on such and such this, और आपको इतना पैसा देना पड़ेगा. So my father said, my son is right in front of me. मेरे एक ही बेटा है. I don't have any other son. So we knew that these things are happening. So I'm not too surprised. Data forgery is at an all-time high, and it's a vast field. So I don't think so I can comment anything else on data forgery other than this. In case if you have any specific thing, then you can definitely ask. What was the second part of your question? Sorry.
The second question, we were talking about the evidence collection at digital level and the cloud transformation of it. The need of the
Evidence
cloud.
collection at what level? Sorry.
For example, if we look at the Indian Evidence Act before,
Mhm.
what is to happen is the cases were pending for so long into the courts, as we can see today. The court is overburdened still, even after the technology integration and also the AI integration. So today, along with the technology integration, today what happened is that we have transferred ourselves on
I think the voice is not audible, Soumya. I lost you.
digital mode of examining forgery of documents. And second is it possible for you to put some insights at least on the cloud storage and cloud transformation in each initiatives and its linkage with the today's BSA and for documentation as an evidence act on digital landscape?
See, I would try to answer both your questions by saying that in terms of evidence gathering and evidence collection and evidence preservation, rather, obviously it plays a very important role. Uh, in some of the cases that come to us, they ask for the age of the ink. Right. So, first of all, age of the ink cannot be deciphered. Nobody can exactly tell by looking at a document that whether the signature was signed in which year, or how old is the signature. Approximately, yes, it can be given in approximation, but that too, once there are certain parameters that have to be ticked before making any comment on that. For example, if I have a document uh, that shows the ink, it's a handwritten document, and there is a slight oxidation that has taken place on the handwriting. When I say oxidation, I mean that the ink of that body writing, that handwriting, has seeped into the document completely. There is a slight feathering. uh, Feathering happens because of the moisture content. So it depends on the keeping condition of the document. So suppose I have a document with me, it's an old document, and I have not made uh, laid any special emphasis on the preservation of the document. It is kept in a room, and it has gone through all the seasons for last 15 years. It has seen hot summers, cold winters, moisture laden monsoons. So it has seen all the weathers for last 15 years. So as a result of which, what has happened is, since I have not preserved it in a proper manner, it is lying somewhere in the room, or maybe in a cupboard, or maybe in a unlocked space. So I would say that the keeping condition would definitely, since I have not kept it in a proper manner, the moisture has gone inside the paper and the feathering has taken place. Now, if somebody in that same document, if somebody comes and inserts another page, for example, another handwritten page, and he carefully pastes it successfully in the document, which is done in 2026, and the document was of the year 2013, 13 years back. So definitely, we can identify, and we can give a subjective, not subjective, I would say, but approximate conclusion, saying that both these sets of writings were taken in different years, not in the same sitting. So when I say it was not, it is supposed to be done in the same sitting. The document is such, it is supposed to be done in the same sitting. But since this page doesn't look that old, why? Because the moisture content is not, it's absolutely different. There's an entire document which has seen all the seasons for the last 13 years, and this is a very fresh document which is maybe made 2 3 months back. So obviously, it is definitely going to show demarcation. It is going to show a huge amount of difference. So I can opine that this document was signed maybe 10 15 years back, and this document is significantly, comparatively, of a recent time period. So that we can do. But as far as if somebody asks and somebody says that I can exactly tell the year also, then he's obviously lying. Nobody can tell an exact year. So preservation of documents plays an important role. Today also, I would say that if somebody is executing a document which is a will, or which is a very important document, or maybe a certificate also for that matter, or an achievement, or any such authority letter, make sure that you keep it, you have to preserve it in a manner so that it people, they laminate it also. But lamination, in later on, if that document is need to be examined by any forensic expert, lamination becomes an impediment. Why? Because lamination does not allow you to have a transmitted light photograph of that document. It is laminated, you cannot reopen it. The document will be, it's a destructive analysis, it is going to be destroyed. And you cannot touch the paper, you cannot make a oblique light examination. If you photograph that document, the reflection of the light is going to come back again. So lamination is not the correct way of doing it. You can either do one thing, you can keep it inside a plastic bag, or whereby, it is not, it is not entirely sealed, but it is not open also. So it is like manual sealing, whereby you can reopen it again and again, but it is kept safely, and then you keep it in some safe, or a vault, or some that kind of a place which is moisture free slightly. So that way, I think you can take care of the document for, maybe 10 10 15 20 years also. As far as cloud is concerned, I'm not too qualified to comment on anything pertaining to cloud, because I am mostly involved with pen and paper. So whenever there is a touch of pen and paper, is the is the reason why I've been called in the past, and I am definitely going to be called in future also, whenever there is a touch of pen and paper. So let I might not be giving you the right information pertaining to the cloud, the question pertaining to the cloud thing. Sorry about that.
Thank you so much, sir. So as we come to the end of today's webinar, I would sincerely thank you, our respected speaker, Ms. Shri Manas Mishra, sir. Thank you for sharing your valuable knowledge and insights on forensic document examination and the legal system. We the Law Codified team, wholeheartedly thank you. I thank each and every participant present in this webinar today. Thank you for giving us your valuable time to us and for attending these sessions. This was indeed a very good session, very good. Some minds can be seen with some good doubts. And Shri Manas Mishra sir, your guidance has been extremely informative and beneficial for all the participants.
Thank you. Thank you so much.
And thank you once again, all of you, to join us for joining us today and making this session very much successful. Thank you everyone for your time, and please be in touch with us because we are going to bring some much more for you all so that you all can uh, sustain very well into the field of law, be in touch with the advancements, and remain abreast of the things. And we are going to just make it more good for you in the upcoming time. Thank you so much, everyone. Thank you so much, sir, once again.
Thank you,
Thank you.
and I'm glad I was part of such a webinar, and I was really impressed by the quality of questions. I'm really impressed. I don't think so. Not a single question was, out of context or uh, it was all the questions were valid, and I was really happy answering all of them. And I hope I could answer each one of you in the way you wanted that to be answered. So thank you very much for having me here, and it was nice being invited on such webinar. Thank you very much.
Thank you, everyone. Please